I would request all the participants to kindly share their time division in the chat box. Total, we have 40 minutes in which the speaker number 1 can take maximum 23 minutes and speaker number 2 can take maximum 17 minutes. Then we have rebuttals. Rebuttals or total round is for 5 minutes, whereas the petitioners can avail it for 3 minutes and the respondent can avail it for 2 minutes. Kindly put this in the chat box. It has to be made sure that no extra time would be given to the speakers. And if any extra time is taken as per the judge's discretion, the marks would be reduced negatively. So kindly put the time division in the chat box. And I also request all the participants to kindly turn on their cameras.
Good afternoon. Sorry for late joining. I hope I am audible and visible.
Yes, sir, you're audible and visible.
Yeah, thank you.
Court Master, could you please clarify the time division again?
Yes, sure. So for the time division, each team has 40 minutes overall, whereas the speaker 1 can take around 23 minutes maximum, and speaker 2 can take minimum 17 minutes. And then you have time for rebuttals, whereas petitioners will go for 3 minutes, and for sir rebuttals, respondent will go for 2 minutes. If that has been made clear, kindly drop your time division so that we can start it soon.
I'm noted. Nande already said.
With the permission of the Honorable Excellencies, I would like to start with the court proceedings.
Please carry on.
Thank you, my lord. So I would like to welcome you all again to the 4th Justice Dipak Misra International Moot Court Competition 2023-2024, organized by the Advocates League. First of all, congratulations to all the participants who have made it to the final rounds. And I'm really thankful to all the judges who have made their time and is present in this current session. The time purifications had been noted, and any extra time that would be taken by the participants with the discretion of the judge would be taken as a negative marks. With this, I would request the participants to keep their identity anonymous and not to share their identity anywhere. With this, we can begin with the court proceedings. A placard would be showed to you at the end of 5 minutes. When the 5 minutes are remaining, and when 3 minutes are remaining, and a message would be dropped for the same so that there is conveniently we can start with this. With this, I would request the petitioner side to approach the bench.
Greetings to the Honorable Bench. This is Counsel number 1 appearing on behalf of the prosecution. The Counsel seeks permission to address this bench collectively as Your Excellency.
Please carry on.
Much
Continue, please.
obliged. Much obliged, Your Excellency. I am Counsel number 1 and I'll be dealing with counts 1A and 1B, while my co-counsel will be dealing with counts 2A and 2B. With the permission of Your Excellencies, the Council would like to proceed with the facts of the present case at hand. Your Excellency, much obliged, Your Excellency. Your Excellency, Republic of Riverland's largest city, Ecolia, is home to the indigenous Ecolian population, and the city is renowned for its pristine environment. The state of Arunkas, situated in the south of Riverlands, shares border with Ecolia. Arunkas has an authoritarian regime with a history of human rights violations and aggressive expansionist policies. The state of Arunkas is under the authoritarian rule of General Demon, who established his authority through a coup d'etat. General Demon has long envied Ecolia for its natural resources and strategic location. In the late 2021, Your Excellencies, skirmishes began to happen between the citizens of Arunka occupying the border villages and the Ecolian people over frequent crossing of borders by the Aruncan citizens. The northern borders of Arunka, though heavily garrisoned, were loosely guarded. In the early 2022, the conflict between the two groups escalated as the Aruncan citizens began to settle and assert their ownership rights on the private lands of these Ecolian people. On the fateful day of February 13, 2022, as the Ecolians gathered at the Heronal temple for worship, Aruncan citizens intruded, displaying their flags and pamphlets, provoking the Ecolians. This led to a violent clash resulting in death of over 40 Aruncan citizens and more than 300 injuries. After General Diamond received the report of this very incident, he commanded his military to not let the sacrifices of his brothers go in vain. In a stirring speech that was verbatim published in a local newspaper, he stated that it is time to take back our land from our enemies. Your Excellency, the very next day after this speech was made, the Aruncan military launched a relentless attack on the Ecolian city, capturing it by the week's end. This attack, Your Excellency, caused widespread and severe damage to environment, reducing large areas to rubbles, destroying homes, and even decimating the green and ancient forests of the Ecolian city. Despite this devastation and occupation of Ecolia by the Aruncan forces, the citizens continued to infiltrate the city. Reports from various local newspapers and NGOs highlighted a mass influx of Aruncan citizens. There were subsequently also reports that General Demon had ordered the reconstruction of Ecolia, and further, there was a report which stated that the Defense Ministry of Arunka had been covertly executing Project Homecoming. This Project Homecoming, Your Excellency, was basically launched with the intention of occupying the territory of Ecolia. The Republic of Riverlands has referred this case to this Honorable Court, which is the International Criminal Court, in December 2023. The ICC's Office of Prosecution had launched an investigation and subsequently issued an arrest warrant for General Demon in 2024. The hearing is currently being held in this pre-trial chamber of the International Criminal Court at the confirmation of charges stage in accordance with Article 61 of the Rome Statute. If Your Excellencies are well versed with the facts of the case, the Council would like to proceed with the charges.
Yes, please.
Much obliged, Your Excellency. I'll be dealing with charges 1 and 2. With respect to charge 1, Your Excellency, that is destruction of the Ecolian pristine environment and the war crime of intentionally launching an attack with the knowledge that such an attack is likely to cause a widespread, long-term and severe damage to the environment. We submit 5 major elements that need to be satisfied under Article 8(2)(b)(4) of the Rome Statute to prove that there was a widespread destruction of the environment. Your Excellency, the very first element of this war crime is that the perpetrator should have launched an attack. Although the term attack has nowhere been defined in the Rome Statute, Your Excellency, but when we turn our attention to the case of Prosecutor versus Palve-Struger, which is mentioned on page 14 of our memorial, it was held that an attack refers to the use of force and to carry out military operation at the beginning or during the course of armed conflict. An essential part of this element is the need to establish a causal connection between the perpetrator and the act. This causal link is very necessary to establish that there is a concrete consequence has been caused by the perpetrator. The causal link here is that General Demon is, as evident from the facts of the case and the Moot proposition, was a military commander who had the authoritarian regime and had directed his people and commanded them to launch attack on the city of Ecolia. Therefore, Your Excellency, the first element of crime satisfies here. Coming to the second element, Your Excellency, which states that any death, injury, or damage should be of such an extent to be clearly excessive in relation to the concrete and direct overall military advantage that is being anticipated. Here, Your Excellency, we submit that the principle of proportionality was significantly breached. This principle of proportionality requires that any damage to civilians must not be out of proportion to the direct military advantage that is being gained. This was held in the case of Prosecutor versus Cupresi. Excellency, you can find this case on page 15 of our memorial, footnote 6. This advantage, Your Excellency, should be definite and not indeterminate. General Demon and his army had caused an overwhelming large-scale environmental devastation, which was in no way definite or in alignment with any of their military objectives. With respect to environment, it is crucial to determine whether the actions were proportionate or not. Your Excellency, if you draw your attention to page 3, para 3 of the Moot proposition, it states that the ancient forests were decimated. If we look into the definition of the word decimated by the legal dictionaries, the Oxford Dictionary and the Merriam-Webster Dictionary, we draw a conclusion that the word decimated means something that is out of proportion and something that brings complete end to the existence and the usefulness of a thing. Therefore, when this decimated attack on forests and the green lush spaces happened, we submit that this attack was not in proportion to the military advantage they were seeking, and it was excessive as it caused widespread loss to their environment, which was irrecoverable. Therefore, the second element satisfies here, Your Excellency. Your Excellency, coming down to the third element, which requires to be proved, is that the perpetrator knew that such a widespread damage would be caused. Article 30, Clause 3 of the Rome Statute establishes that knowledge means awareness that a circumstance exists and the consequence will occur in the ordinary course of event. What this mental element requires is a virtual certainty, a practical certainty that it would definitely happen. General Demon, as a commander, was fully aware of the type of weaponry his military had. There was a particular military strategy that was employed for launching this very attack, as has been referred to in page 3, para 3 of the Moot proposition itself. Being an authoritarian leader who was aware the kind of advanced weapons his military has and the kind of launch attack they can launch, it is unlikely that General Demon was not aware that this weaponry would cause such a large-scale unintended consequence in terms of environmental crime. He launched a full-scale attack, and therefore this element that perpetrator knew that such a damage would be caused is satisfied in the present case. Coming to the fourth element, Your Excellency, which states that there should be a nexus between the conduct and the international armed conflict. As it was proven in the case of Prosecutor versus Dusko-Tadic, which is mentioned on page 16, footnote 15 of our memorials, Your Excellency, an armed conflict is said to be international if it takes place between two or more states. Additionally, in the case of Prosecutor versus Kuranak, which is on page 17, footnote 17 of our memorials, Your Excellency, It states that if the perpetrator acts in furtherance of or under the guise of an armed conflict, it would be sufficient to determine that the acts were related to an armed conflict, thereby establishing the nexus that is required. The state of Arankas was already involved in skirmishes with the Ecolian people since the early 2021 itself, and deliberately German demon target the environment under the cover of a conflict and caused damage that was far beyond the military advantage, showing that there was a calculated move to assert control over the Ecolian land. And therefore, Your Excellency, even the fourth element of this crime gets satisfied here. Now moving on to the fifth element, Your Excellency, which requires an awareness of the existence of an armed conflict on the basis of factual circumstances. It is humbly submitted, Your Excellency, that General Demon was aware that there existed an armed conflict on the basis of factual circumstances that was present before him. A general awareness of the factual circumstances is enough to establish this element, and it is not required that the perpetrator should be aware of all the specific crimes that are being committed. General Demon, in the present case we submit, was fully aware of the factual circumstances that there exists an armed conflict because these very skirmishes were happening when he was an authoritarian leader from the period of 2021 to 2024. He was aware. Further, after the violent clash that happened at the Herenol temple, there was significant escalation and a clear indication that the situation was spiraling out of control. However, immediately after this incident, General Diamond got the report of this incident. And after getting the report of this incident, he commanded his military to retaliate. This indicates that he was aware that there is a nature of crime that is happening, and therefore the fifth element of crime, which requires that the demon was aware that there existed an armed conflict on the basis of factual circumstances, gets satisfied in the present case, Your Excellencies. If Your Excellencies do not have any queries with respect to count 1, the Council seeks permission to begin with count 1B.
Yes,
Please carry on.
Much obliged, Your Excellency. Your
No
Excellency.
questions I have. Oh, we have no questions.
Yes. May I continue, Your Excellency? Much obliged, Your Excellency. With respect to count 2, which is individual criminal responsibility for ordering the commission of a crime under Article 25(3)(b), we submit 4 elements which needs to be satisfied for establishing individual criminal responsibility for ordering. These 4 elements are identified in various cases by the International Criminal Court itself, such as Prosecutor versus Bosco Naganta and Prosecutor versus Sylvester, which are mentioned on page 18 of our memorial, footnote 19. The 4 elements would be satisfied by the council here. The first element is that the person should have assumed a position of authority. Your Excellency, the term order or ordering as used in the statutes has been defined as an act of a person in position of authority, using this very authority to persuade, command or coerce someone to commit that very offense. Crucially, what this requires, Your Excellency, is a clear superior-subordinate relationship between the individual issuing the order and the one that is carrying out that order. In the present case, Your Excellency, it is unequivocally evident that General Demon, by virtue of his military command, holds such superior position, and his role as this authoritarian leader with absolute control over the national security and the armed forces solidifies this dominance and the superiority element. Coming to the second element, Your Excellency, which is that the person instructed another to perform an act in the execution of a crime which is carried out. Your Excellencies, in the case of Prosecutor versus Stanils of Gallic, which is mentioned on page 19, footnote 23 of our memorial, the court highlighted that the responsibility for ordering requires a proof that a person in position of authority uses that very particular authority to instruct another person to commit an offense. To establish that General Demon had instructed to commit this very offense, we need to look at the factual circumstances of the present case. In the aftermath of the violence, General Demon commanded his military to not let go the sacrifices go and therefore he further stated that it is time to take back our land from our enemies. This statement by itself is indicated of the fact that he instructed his military to order the commission of a crime. Secondly, Your Excellency, if we look at the Balsic trial judgment, it stated that there is no requirement that any order given by a superior must be in any particular form, such as writing or in any specific form. It can be an either express order or an implied order. In the present case, this was an express order wherein he implied order wherein he stated to his military that it's time to take revenge back and it's time to take the revenge of the sacrifices of our brother and sister. Therefore, this very element, the second elements get satisfied in the present case, Your Excellency. Coming to the third element, Your Excellency, it states that an order should have a direct effect on the commission of a crime. The requisite actus reus for individual criminal responsibility is constituted by an act of participation, which has an effect on the commission of a crime. Hence, this order must have a direct and substantial effect on the commission of a crime. There are reasonable grounds, Your Excellency, to believe that General Demon's act of ordering had a direct effect on the commission of crime. This direct effect can be established, number one, by his authority over the direct preparators, which is the Arankan military, coupled with the fact that the Arankan military launched a full-scale attack on Igpolia with overwhelming force just a day after this historic speech was made and this command was made. The very fact that a day after this command, this attack was launched, satisfied the third condition. The timing and the scale of this attack solidifies the connection that is needed between General Demon and his orders. Therefore, the third element gets satisfied here, Your Excellency. Coming to the fourth element, Your Excellency, it states that in order to there should be an intent, awareness that crime should be committed in the ordinary course of events. Your Excellency, mental intent is the one of the major factors while establishing the criminal liability of any person. In the present case, we humbly submit that there was mental intent on the part of General Demon. Article 30 of the Ring Statute provides that any person shall be criminally responsible and liable for punishment of a crime within the jurisdiction if the material elements are committed with intent and knowledge. In the case of Prosecutor versus Nahimana, which is mentioned on page 20, footnote 31 of our memorial, Your Excellency, the mens rea for responsibility of ordering is satisfied, firstly, when there is a direct intent to order the commission of a crime, and secondly, there is an awareness that crime would occur in the ordinary course of events. Firstly, Your Excellency, the intent to order the commission of crime can be gauged from the statement of General Demon, wherein General Demon's command to his military and his speech clearly indicates his intention to order the commission of war crime attacking the civilian population of Ecolia. By instructing the military to take the land back from enemies, he initiated a forcible armed conflict that would inevitably result in civilian casualties. Your Excellency, this intent can further be gauged by the fact that General Demon, even after becoming aware that these crimes are happening, did not make any effort to stop these very events. In the ICC, it can be a defense that when the person assuming authority gets to know that there is something that is a violation that is happening, stops that very attack or makes an effort to stop it. However, in the present case, Your Excellency, going by the fact sheet, there is no single evidence that he made any effort to stop that very effect. In fact, this entire violation of entering into territory of Ecolia was happening over a period of 2 years. And for 2 years, he did not make any effort at all to stop it. Therefore, the intent gets satisfied here. Coming to the knowledge element, Your Excellency, knowledge means an awareness that the circumstance exists or a consequence will occur in the ordinary course of events. And this knowledge and virtual certainty that crime would occur in the ordinary course of events gets satisfied by 2 points. Firstly, the past history. General Demon was aware of the past history of conflict between Ecolian and Arankan citizens. He knew that since 2021, these skirmishes are happening, and even these border violations are happening. Therefore, he was aware, even after the conflict that happened at the Heronal Temple, it was a flashpoint event that happened. He even was reported of this Heronal conflict. His awareness to these tensions implies the knowledge that any aggressive action could lead to violent outcomes, and therefore this element gets satisfied. Coming to the second part of it, that he had the knowledge of advanced weaponry and widespread attack. If your lordship look to the fact sheet, page 3, in the heading Aftermath Para 2, it states that the Arankan military launched a full-scale attack with overwhelming force and intensity, and they were leveraging their advanced weaponry and strategic military planning. Your Excellency, a full-scale attack was launched and was executed with an overwhelming force, including advanced weaponry. Being being a person who is in authority, he must have the knowledge, the kind of weaponry that his troops would be employing in this very attack. The destruction that was caused, including the devastation of the environment, infrastructure, and harm to civilian, was a direct consequence of these very military actions. Since he was an authoritarian leader, no no action could have been taken without his command, and that too on such a wide scale. Therefore, Your Lordship, since all these elements are satisfied, we humbly submit that these two charges should be levied against General Demon. And now, if Your Excellencies do not have
Just one
any.
question. Was there a direct order? Because what you're implying is the circumstantial evidences or circumstantial statement which were made by the general. Were there specific orders, direction?
Your Excellency, if you look at page 3, para 2 of the proposition, it states that as soon as he got a report of the horrific incident, he commanded his military to not let the sacrifice go in vain. And this speech was a verbatim speech, which means that this was a recorded.
Since he was also the ruler, so was it not expected of a ruler, and was on secondly he was in the capacity of the army. So was it a specific direction or was it an order? Or was is the councils aware that there was specific order? Proposition doesn't speak about it. What are your views on it?
Your Excellency, although the proposition does not talk about there was an explicit order, we solely relied on the term command. However, Your Excellency, for a moment, even if we suppose that there was not an explicit order, if you look at the very facts of this case, he gives a speech. The very next day, such a widespread attack happens. Now, if you connect all the links of this very proposition, you'll realize that there was an order on part of General Demon, because such a widespread consequence would not have occurred without his permission. And the timing and the scale of the attack solidifies this connection, that the order was on behalf of him. And even if we look at the history, that he had long envied Ecolia of their strategic and military military location. And by connecting all these dots, even if we consider that there was not an explicit order, which we do not agree to, we feel there was an explicit order, then also we can clearly, by way of the circumstantial evidence, corroborative evidence, and even the recorded speech, can infer that there was an order on his part.
Okay. Okay. And was it not whether retaliation would also be considered as it could be the force of retaliation could have happened without his
Sorry, Your Excellency, it could have been retaliation, but Your Excellency, retaliation should always be proportional. Retaliation does not mean that you will occupy the other country's territory. Retaliation should always be based on the principle of proportionality, and it should not be in excess of what is anticipated. Here, the retaliation was excessive in terms of the widespread damage it did to the civilian population and even the environment, and therefore. As you said, that retaliation was not there. This was clearly an intent to launch an attack.
Okay, get it.
Your Excellency, with your permission, now I would like to pass on the floor to my co-counsel for dealing with counts 2 and 2B.
Yes, yes, please.
Am I audible and visible?
Yes, you are. You are audible, ma'am. Please carry on.
Greetings to the honorable bench. May the council begin.
Yes, please.
Much obliged, Your Excellency. The council is appearing on the behalf of the prosecution in issue 2A with respect to Project Homecoming, the war crimes of transferring by the occupying power of parts of its own civilian population into the territories it occupies. If it pleases the court, may the council begin with the submissions?
Yes, please.
Much obliged, Your Excellency. Today, the council is here to prove that General Damien should be held liable under Article 8(2)(b)(8) of the Rome Statute. For the same, the council will prove 3 arguments before this honorable bench. Firstly, Your Excellency, the council respectfully submits that the conduct by General Damien took place in the context of and was associated with an international armed conflict. For conduct to qualify as a war crime, a nexus must be established with the armed conflict. An armed conflict exists when there is a resort to armed force between states or prolonged violence between authorities and armed groups. A conflict occupies the nature of an international armed conflict when it occurs between 2 or more states, as stated in the case of Prosecution versus Katanga, found on footnote number 34 of our memorial. The involvement of military force between states automatically triggers the application of international humanitarian law, as further clarified in the case of Prosecution versus Static, found on footnote number 37, Your Excellency. There was also a nexus between the conflict and the conduct that took place in the present case, which can be assessed on the basis of the criteria provided in the case of Prosecution versus Kunarak, which is found on footnote number 38. Your Excellency, in the present case too, the victim was a member of the opposing party, and the act of transferring people into the occupied territory was the ultimate goal of the military campaign. Project Homecoming, which was initiated in the year 2021 as part of Arankan's expansionist policy, led Arankan citizens to encroach upon and cross into Ecolian territory. The conflict escalated when Arankan citizens forcibly entered an Ecolian temple on the 13th of February, year 2022. The ensuing military campaign sought to seize Ecolian territory, and Arankan authorities began relocating their civilian populations into the occupied areas. Thus, a reasonable nexus was established between the conduct and the international armed force. Secondly, Your Excellency, the Council respectfully submits that General Damien was aware of the factual circumstances that established the existence of an armed conflict. According to the elements of crime, one common element of war crime is that the perpetrator was aware of the factual circumstances that established the existence of an armed conflict, as also affirmed in the case of Prosecution versus Jean Pierre Bamba, found on footnote number 39, Your Excellency. It is sufficient that the perpetrator knew or should have known of these circumstances, as the situation would be so obvious that no additional proof of the perpetrator's awareness would be necessary. The perpetrator need not legally evaluate whether an armed conflict was international or non-international, but must be aware of the factual circumstances indicating its existence, as also clarified in the case of Prosecution versus Bosco, found on footnote number 41 of the memorial. In this case, Your Excellency, the Arankan military launched a full-scale assault on the Ecolian city, which cannot be possible without the knowledge and support of the Supreme Military Commander. Despite the ongoing attacks and occupation, Project Homecoming continued with Arankan civilians being transferred into occupied Ecolian territory. As the military commander of Arankas, the General Damien had clear awareness of the circumstances establishing the armed conflict between the two states. Thirdly, Your Excellency, the Council respectfully submits that as there was an international armed conflict, the act of transferring its own civilian population into the occupied territory amounts to a war crime. Your Excellency, Article 82B8 of the Rome Statutes prohibits an occupying power from transferring parts of its own civilian population into an occupied territory. This prohibition is also reinforced by Article 49(6) of the Geneva Convention 4. And this prohibits the deportation or transfer of an occupying power civilian population into an occupied territory. Your Excellency, General Damien's actions, as revealed in the newspaper report, show that Project Homecoming was a deliberate strategy to transfer Arankan civilians into Ecolian territory. And despite the devastation and ongoing occupation, General Damien facilitated and encouraged the mass relocation of Arankan civilians, as corroborated by reports from local newspapers and NGOs. General Damien was fully aware that such transfers were prohibited, yet he systematically sought to alter the demographic composition of the occupied territory. With the permission of Your Excellency, may the Council move to the next issue?
Yes, please.
Much obliged, Your Excellency. Next, the Council will now prove the issue of 2B on the basis of superior responsibility pursuant to Article 28(1) of the Rome Statute. Your Excellency, the Council will prove that General Damien is liable under Article 28(1) of the Rome Statute. For the same, the Council will present 3 arguments before this honorable bench. Firstly, Your Excellency, the Council humbly submits that General Damien is criminally responsible by virtue of being a military commander himself. Article 28(1) of the Rome Statute establishes that a military commander or someone acting in that capacity is criminally responsible for crimes committed by force under his command or under her command for that matter. General Damien here holds effective command over the Arankan military. And after seizing power through a coup, he became the superior commander. In the case of Prosecution versus Milorad, which can be found on footnote number 48 in the memorial, it shows that the commanders are accountable for failing to control their forces, even if they did not directly commit crimes. The same is asserted by the International Committee of the Red Cross. The relentless bombing in Eccolia under the general's directive to take back, and I'm quoting Your Excellency, to take back our land from the enemies suggests his direct involvement. Moreover, it is clearly mentioned, and if Your Excellency could please refer to page 3, para 2, line 1 of the proposition, it is clearly mentioned that General Damien had commanded his military to not let the sacrifices of our brothers and sisters go in vain. Moreover, Project Homecoming implicates him further. Reports indicate that this covert operation aimed to annex Eccolia by displacing the indigenous population, and as the head of the state, General Damien likely had the ultimate authority over it. Secondly, Your Excellency, the Council humbly submits that General Damien had knowledge of the crimes about to be committed. Under Article 28(1) of the Rome Statute, a military commander is held responsible if they knew or should have known about the crimes committed by their subordinates and failed to prevent them. As stated earlier, Your Excellency, General Damien's speeches, particularly those after the Harrenhal incident, provide compelling evidence of his intent and knowledge regarding military actions, leading to war crimes. As Supreme Commander, Your Excellency, his control over military operations implies awareness of the systematic crimes committed by his forces. Moreover, a superior's failure to prevent and punish known crimes signals acceptance or encouragement, increasing the risk of further offense. This was also affirmed in the case of Prosecution versus Prosecution versus Kubura, found in footnote number 57 of the memorial. The appeals chamber of the ICTY also clarified in the case of Prosecution versus Struggle, found on footnote number 55, that a superior is liable if they receive sufficiently alarming information that warrants further inquiry into potential crimes by subordinates. Following the Harrenhal incident, Your Excellency, clear evidence indicates that a significant risk of grave violence, of grave violence, of hostility, if the hostilities continued. This was very evident. But nevertheless, Your Excellency, General Damien's commanded his troops to take actions in his speech. His awareness of previous offenses by his people should have alerted him of the likelihood of similar crimes being committed by the same group of people in the same area in future. Thirdly, Your Excellency, the Council humbly submits that General Damien had effective command or authority over the forces. Article 28(1) of the Rome Statute holds that a military commander is responsible for crimes committed by subordinates if they exercised effective control, meaning that they had the ability to prevent or punish those crimes. Effective control is defined as the practical ability to prevent subordinates from committing crimes and involves the authority to issue and enforce orders. As established in the case of Prosecution versus Delale, which can be found on footnote number 60 in the memorial, Your Excellency, indicators of effective control, including overseeing combat operations, enforcing discipline, and managing troop promotions are entailed within it. Your Excellency, General Damien, as the supreme commander of the Arankan military, clearly held ultimate authority over all military operations. The hierarchical structure of the military indicates that his commands were executed without question, establishing his effective control. International law requires commanders to prevent and punish crimes by their subordinates. This responsibility arises from the commander's failure to act, as noted in the case of Prosecution versus Helilove, which can be found on footnote number 62, Your Excellency. The extensive devastation in Ekolia, resulting from the deployment of the Arankan army, underscores Damien's duty to control his forces. Commanders are uniquely positioned to maintain discipline and prevent violations, as highlighted in the case of Prosecution versus Ignace, which can be found on footnote number 65 in the memorial. To conclude, Your Excellency, the Council requests that General Damien should be held liable for not only transferring his civilian population into the occupied territories of Ekolia, but also he should be held responsible under the principle and doctrine of superior responsibility under Article 28(1), as he was not only the military commander, but he also had effective control over the actions of his subordinates. He also had the knowledge of the crimes that were being committed, and he did not do anything to punish or prevent these crimes. If Your Excellency is satisfied, may the Council move to the prayer.
Please carry on, ma'am. There is no question at
Much
all.
obliged, Your Excellency. Much obliged. Your Excellency, the counsels for the prosecutions which humbly submits that this honorable court finds, adjudges, and declares that in the present case, number 1, General Damien be held liable for war crimes for intentionally launching an attack with the knowledge that it would cause widespread, long-term, and severe damage to the pristine environment of Ekolia. Number 2, General Damien be held liable under Article 25(3)(b) of the Rome Statute for individual criminal responsibility, as he ordered the commission of a crime that in fact occurred. Number 3, General Damien be held liable for his involvement in Project Homecoming for the war crime of transferring by the occupying power of parts of its own civilian population into the territories it occupies. And number 4, General Damien be held liable based on superior responsibility under Article 28(1) of the Rome Statute, and pass any other order that it may deem fit in the interest of justice, equity, and good conscience. With that, Your Excellency, the prosecution would like to rest their case. Thank you.
Thank you.
Thank you, Excellency.
The counsel on the behalf of defense seeks permission to kindly address the bench as Your Excellencies and individually as Your Excellency.
Please carry on.
Much obliged. The counsel, on the behalf of defense, humbly submits to the jurisdiction of the submits to jurisdiction in the pertinent matter. The counsel 1 will be dealing with the issue number 1A and 1B, and the counsel 2 will be dealing with issue number 2A and 2B. If Your Excellencies are well versed with the facts of the case, the counsel seeks permission to proceed with his arguments.
Please carry on.
The counsel 1 will be dealing with issue number 1 in a twofold manner. First of all, that there was a retaliation which was based on a reasonable apprehension and not constituting an attack. And secondly, Your Excellency, that the consequences of retaliation was not intentional. It is humbly submitted before the Honorable Pre-Trial Chamber that the action from the side of General Damon was done due to the reason that the extent of the response of Ecolan population was not proportional to the magnitude of the harm caused to them. And it is thereby submitted that the killing of 40 persons cannot be considered as justified ground on the part of Ecolans to counter the tranquil interference from the side of Aranka civilians. Your Excellency, the tranquil interference is defined as per ICRC interpretive guidance on direct participation in hostilities as a non-violent interference, which basically might include a protest, etc., without involving any of the violent act. The Arankan citizens who entered into the temple of Haranal is justified on the ground that Arankans considered the land of Ecolia as their ancestral land, and as per the factual matrix itself, it can be interpreted from this that they have a former sense of deep belongingness with that land. Your Excellency, it is humbly submitted that to test the legality of any attack, three things need to be considered very judiciously. That is necessity, immediate need, and proportionality. And these should be interpreted in a widest possible manner as observed by the Honorable Chamber in the case of Prosecutor versus Poskonatanga. And in the pertinent case, Your Excellency, the actions by General Damon were basically based on to retaliate because of the loss suffered by the Arankas. Secondly, there was a menace to the national security, and most importantly, Your Excellency, his actions are primarily directed against the military combatant itself. It is humbly submitted that these actions itself, the actions of General Damon itself fulfill the parameter that the attack was a very strategic and also targeted to only the specific areas, Your Excellency. It is further submitted, Your Excellency, that the objective of military advantage should also be taken into consideration along with the above three grounds, which is defined as an intermediate concept without a precise meaning, and that should not be interpreted in a narrow sense. And in the pertinent case, the main motive of General Damon, even after gaining the control over the Ecolia, was not to cause the destruction, but to restore its former glory, as specified by the factual matrix itself, Your Excellency. Moving forward with another subcontention that the consequences of the retaliation was not intentional. It is humbly submitted, Your Excellency, that in case of Prosecutor versus Jean Bemba Gombe, the Chamber emphasized on the fact that the should have known element might not be present and is therefore cannot be treated as a sole basis to consider one guilty. And in the pertinent case alleging the General Damon that he should have known the extent of damage the military skirmishes would cause is completely unfounded. Further, the factual matrix is also clearly states that the Arankans consider the land of Ecolia as an ancestral land and nature as their mother, which clearly indicates that the destruction caused to it cannot be intentional, as the essential steps, Your Excellency, such as strategic planning as well as the use of advanced weaponry. Your Excellency, the advanced weaponry generally includes arms such as precision guided munitions, modular missiles and payloads, cruise missiles, etc., that have a specific precision and pinpoint striking capabilities. It is thereby completely can be showed from this fact that the main aim of the General Damon was to target the military combats and the specific areas and not the civilian areas as such. Further, it is humbly submitted that, Your Excellency, that the prosecution need to prove beyond the reasonable doubt as under the ICTY Rule 87A of Rules of Procedure and Evidence explicitly say that a finding of guilt may be reached only when a majority of the trial chamber is satisfied the guilt has been proven beyond the reasonable doubt by the prosecution itself. The prosecution needs to prove it reasonable doubt, mainly to denote the malified intentions of the general demon. But it is most humbly submitted, Your Excellency, that any such intention is not displayed, even from the speech of general demon, as stated by the prosecution, because there was no such use of word revenge in the speech given by me. Your Excellencies may read with me para number 5 under the head of the aftermath. He clearly says that it is the utmost important time for all of us that and our brothers and sisters have sacrificed their life, and now is the time to take back our land. It is basically portraying, Your Excellency, the intention of retaliation rather than causing destructive harm to the equal, Your Excellency. And further, as per the case of Prosecutor versus Jaman Ketanga, the legitimacy of military action can only be challenged when the primary objective is to harm civilians. But in the pertinent case, any such motive is not present because actions were taken on the part of General Damon to like strategic planning and use of advanced weaponry to cause the minimal harm possible. Further, Your Excellency, as per K. Ambos, a renowned German jurist, in his commentary, the Rome Statute of International Criminal Code stated that in order to consider one guilty for intentional attack, there should be an attempt on his part to directly incite. I repeat, directly incite, that leads to the commission of crime, which basically here refers to a direct communication on the part of General Damon. Further, the trial chamber has also emphasized at several instances that the mere destruction should not be a sole ground to declare one liable, as the malified intent behind such attack should also be considered equally important. But in the pertinent case, Your Excellency, there was no such intention on the part of General Damon, because the destruction caused was basically due to the fierce armed resistance from the side of state of Riverlands also, and hence the destruction cause should not be considered as solely unilateral, because it is because it's unintended on the part of Damon itself. Further, Your Excellency, the International Court of Justice, with a broader ambit, in the case of Nicaragua versus United States, also recognized the principle that the damage, including the environmental damage, may occur during the military operations which took place due to the provocation from the other side, which, Your Excellency, is the violent killing of 40 Arankans by the Ecolian people who entered the temples while Ecolians were worshipping. But, Your Excellency, the point that should be noted is that there was no such violent act from the side of Arankans, as they were merely hosting the flags and pamphlets on the wall. But they didn't interrupted the worship of Ecolian people in a violent manner. And, Your Excellency, even after such instigation from the part of Ecolian people, there was no such unplanned attack from the side of General Damon itself, because his aim was not to cause the widespread destruction, but to target mainly the military combatants. Further, Your Excellency, if we look towards the case of Prosecutor versus Slobodan Milosevic, the trial chamber found that the Milosevic was a part of a joint criminal enterprise for taking out the destructive measures, which showed his clear intent of having a planned policy. And further, he clearly portrayed his awareness about the serious consequences that might arise after the planned policy. And hence, he was considered guilty of war. But in the pertinent case, there was no such indulgence from the side of General Damon in any of the criminal enterprise, as they were not operating to cause destruction, but against the potential threat that might have arisen to the interference from the side of Riverlands because of the already disgruntled population of Ecolia. And at the end of the day, there was a fierce resistance, a fierce armed resistance from the state of Riverland that further led to the destruction of the environment of Ecolia. And also, it is humbly submitted that where the damage is unprecedented under the grounds of national security or the menace to the national security, then, Your Excellency, it should not be considered as intentional or unilateral. Further, Your Excellency, as far as the specific or a special intention or to cause destruction is concerned, it should be there for causing a war crime of environmental destruction. But in the pertinent case, Your Lordship or Your Excellency, the retaliation by Arankan Defense Forces does not justify a sufficient intent on the part of General Damon of destroying the land which they believed to be their ancestral land, because the consequences arose, as stated by the council earlier, were not unilateral. The trial chamber also emphasized the importance of special intention in the case of Prosecutor versus Blagojevic and Jokic. Further, it is humbly submitted, Your Excellency, that unprecedented, unfortunate damage or destruction resulting from military operations without a requisite intent to target the civilians, infrastructure and civilians as per se, or commit crimes against them, would not meet the threshold of war crime, and thus it does not specify the requisite intent or requisite of the special intent. Further, Your Excellency, the ambiguity of widespread, long-term, and severe damage under Article 8, subsection 2, subclause B, subclause 4 also raises a specter of rule of lenity. As per Article 22, subsection 2, the Rome Statute clearly stated the definition of crime shall be strictly construed and shall not be extended by analogy. In case of ambiguity, the definition shall be interpreted in the favor of person being investigated, prosecuted, or convicted. Therefore, it is humbly submitted that the general daemon should not be charged under Article 8, subsection 2, subclause B, subclause 4 of the Rome Statute for unintended collateral damage and proportionate military advantage. If Your Excellencies are satisfied with the count 1, the Council seeks permission to move forward with the count 2.
Thanks. Anyone from defense speaker? Any other person?
Indeed, Your Excellency.
Now you have completed your argument?
No, I have just asked Your Excellency to move forward with the second count.
Please carry on. Please continue your argument.
Much obliged, Your Excellency. The second contention is basically about the general daemon does not hold the individual criminal responsibility pursuant to Article 25(3)(b) of the Rome Statute, Excellency. It is humbly submitted before the Honorable Pretrial Chamber that if the actions were within the bounds of what is considered necessary for military operations, even if they resulted in unintentional environment harm, then, Your Excellency, they should not be considered as a basis to fall within the ambit of Article 25(3)(b). And therefore, keeping this principle in mind, the retaliation by the general daemon should not fall within this ambit. Further submitted that, Your Excellency, that environmental destruction caused even due to an indiscriminate attack should not constitute automatically a ground of liability, as it should be decisive under the subjective element of attack. But in the pertinent matter, there was no such indiscriminate attack as stated by the Council earlier. That the attack was done with that the word used in the factual matrix, strategic planning, is basically used to refer the planning in terms of targeting the specific areas and not the widespread areas. And also, the advanced weaponry itself will not target the area beyond the specific limit, because the intent of the accused is not to cause destruction, but to target the military combatants as such. Further, Your Excellency, a military commander as a head of armed forces is expected to think rationally as well as to plan strategically. And in the pertinent case, Your Excellency, this duty has been fulfilled up to a great extent by the general daemon, as his main motive was to limit the areas of attacks. And also, as stated in the factual matrix, the word uses vast area, which nowhere shows that the retaliatory actions of the daemon were directed against the civilians or area which are densely populated by the civilians. Therefore, the military action should be considered parallel to the military objectives and should be considered as a mechanism to avoid adverse repercussions. It is humbly submitted that the general daemon, Your Excellency, also adhere to the Article 48 of Additional Protocol 1 of Geneva Convention, which requires a party to conflict to distinguish between the civilian population and the military combatants. And in the pertinent case, there was no such primarily targeting of civilians as such. Then there should be considered as an attempt of general, Your Excellency, to limit the adverse condition which might have arisen, which itself shows that the general daemon recognized the above principle. And Your Excellency, it is humbly submitted that if there is a direct or an indirect threat on the national security of any country, the commander or superior in charge is bound to take a right step, which, as stated by earlier, became necessary because of the actions of which became necessary because of the actions of disgruntled Ecolian population and the potential involvement of riverland states, as there was a threat on national security, is a very concerning factor, and superior in charge is expected to act judiciously. Further, Your Excellency, under Article 51, subsection 5, subclause B of Additional Protocol 2, states that if a civilian casualties or environmental damage caused were not disproportionate to the anticipated military advantage, then the commander should not be considered guilty. Your Excellency, moving forward, for individual criminal responsibility under Article 25 of the Rome Statute, the accused is required to work on a common plan and also needs to have a contribution in a pre-planned policy. But in the pertinent case, as stated by the council, the common plan or the pre-planned arrangement is nowhere present on the part of Damon because his actions were based basically in response to the massacre of 40 Lankan casualties. And importance of the common plan is also showed in the case of Prosecutor versus Radoslav Branin, also Your Excellency, where it is observed that consequences occurred without having any pre-planned intention of committing crimes. Then it should not make a person automatically liable under Article 25 of the Rome Statute. Further, Your Excellency, it is humbly submitted that that one should not be considered individually criminal responsible under Article 25 3b of Rome Statute, only because on the basis of its superior identity, because it is not a decisive criteria. Rather, it is the malified intent as well as the failure to prevent the adverse conditions that actually matters, as observed by the Honorable Trial Chamber in the case of Prosecutor versus Goran Jealousy. Further, in a pertinent matter also, Your Excellency, the mere fact of General Damon being a military commander should not automatically make him individually criminal responsible under Article 25 3b of Rome Statute, because the nature of his actions were not destructive. It is most humbly submitted that individuals should not be considered guilty under Article 25 merely on the basis of speech given by him and published by a local newspaper, because the wordings published in a news journal can be altered accordingly, which refers to the possibility of biased journalism in the mass media, Your Excellency. Further, Excellency, it is humbly prayed before the Honorable Trial Chamber to kindly consider the fact that if the military operations were within the within the ambit to maintain to the proportionate responses to the military threats, which might have resulted in the environmental destruction and other losses, which was unintended consequence of legitimate military operations and were aimed at achieving legitimate military objectives, defending against perceived threats, and most importantly, if there is no intent to unlawfully destroy the environment or forcefully displacing the population, then action should be considered consistent with the lawful military conduct, and any damage caused should be taken as proportionate to the legitimate military objectives, as these conditions are clearly met by the General Damon in the pertinent case. Therefore, it is humbly prayed to the Honorable Pre-Trial Chamber that he should not be held liable for the individual criminal responsibility pursuant to Article 25 3p of ICC. If Your Excellencies are satisfied, the Council seeks permission to pass the floor to his co-counsel.
Council, there are a couple of questions. First one is regarding the facts. Like you mentioned that while this attack happened, what are the safeguards that were taken to see the victims are not common citizens, but they are all military people? So what is your response to that?
Much obliged, Your Excellency. The Council would like to state the para 6 of the factual matrix itself, where it was used that the word used was the advanced weaponry as well as the strategic planning, Your Excellency. And strategic planning should be inferred in the context that there was a planning on the part of Damon to target the specific areas. And as stated by the Council itself, that advanced weaponry has a pinpoint precision, Your Excellency. Therefore, they are basically aimed to target the specific areas, which therefore show that distinguishment between the combatants and the civilians are made on the part of Damon, because his target were the military combatants and not the civilians as primarily. And Your Excellency, it is humbly prayed that the consequences arose after the fierce military armed resistance from the state of Rebuttals should not be considered unilateral, because it was unintended on the part of Damon itself.
Thank you. And on the second point, with regard to the environmental damage, do you think that ecocide, which has been touted as a new crime, as a crime against humanity, do you think that that should be enforced, and whether the present statutory system is suitable for that?
Pardon, Your Excellency, can you?
I'm telling about the environmental damage side, which is the second aspect of the fact that ecocide, which is considered as a new crime against humanity. Do you think, as a council, as an officer of the court, that that should be considered as a crime against humanity? What is your view on that?
So in the reference of the pertinent matter, Your Excellency, it is humbly submitted that the crime of the ecocide is not intentionally committed because their response was to target the environmental sites, and it should not be. It is humbly prayed that it should not be treated as a crime against humanities when it is not primarily targeted against the civilians, as in the pertinent case, Your Excellency.
Thank you.
Much obliged, Your Excellency. It's been an honor arguing for this honorable bench.
Greetings to the bench. Am I audible?
Yes, please, you can proceed.
Much obliged, Your Excellency. Your Excellencies, the Council shall be dealing with issues 2A and B, corresponding to counts 2A and B that the accused General Damon is charged with. Starting off with issue 2A, that is, in respect to Project Homecoming, whether the accused has directly or indirectly transferred parts of civilian population. Apologies, Your Excellency. Starting off with issue 2A, that is, Your Excellency, is this a technical error that I am facing, or is it? I'm sorry, if the time could be stopped. You're under. Much apologies on the part of the Council, Your Excellency.
No problem. Please proceed.
Much obliged. Starting off with issue 2A, that is, in respect to Project Homecoming, whether the accused has directly or indirectly transferred parts of civilian population into occupied territory. The war crime of transferring civilian population into occupied territory, Your Excellency, is enshrined in Article 8, Para 2, Sub-Para B, 8 of the Rome Statute of the International Criminal Court. Your Excellencies, the Council shall be dealing with the pertinent contention in a twofold manner. The first aspect of the argument shall establish that the acts of the accused fail to satisfy elements of crime required for the relevant article under the statute. The second pillar of my argument, Your Excellency, shall seek to establish that the accused did not possess the requisite intent and knowledge relevant to the crime which is required under Article 30 of the ICC statute. Your Excellencies, beginning with the first leg of my argument, the Council would like to guide the bench through the elements of the crime relative to the article to get a proper understanding of the article that contains the war crime the accused is charged with. The first two elements of the crime state that the conduct must have taken place in the context of an armed conflict, and the perpetrator must have knowledge of the factual circumstances establishing an armed conflict. Moreover, Your Excellency, the element the defense humbly requests the bench to focus on is the third one, which states that the perpetrator must have, directly or indirectly, transferred parts of its own civilian population into occupied territory. Your Excellencies, the accused, General Damon, is the superior commander of the Iranian Defense Forces, whom he ordered to retaliate in the face of the loss of 40 civilian lives suffered by the Iranian population at the conflict of Harrenhal on 13th of February 2022. Your Excellencies, it is humbly submitted that in the pertinent case, the acts of the accused fail to satisfy the conditions of dolus directus of the first and second degree, which are both important conditions of criminal liability and were respectively defined in the case of Prosecutor versus Thomas Lubanga DLO. The first was defined as an important condition that requires the actor to have the purpose of bringing about the criminal result with the presence of will. And the second is applicable if the person, a person is aware that the circumstance exists or a consequence will occur in the ordinary course of events. In the pertinent case, Your Excellencies, there is an absence of a volitional as well as cognitive element on the accused's part, as he did not intend to cause the transfer of the civilian population into Ecolian territory, nor did he involve his military to undertake any action in pursuance of a policy of direct transfer. Moreover, Your Excellencies, there is no concrete evidence that links General Damon to the transfer of civilians into Ecolia, and that shows that this was a direct consequence of orders meted out by him. In reference to dolus of the second degree, Your Excellencies, it is humbly submitted that the accused was not aware that the effects of the retaliation ordered by him would lead to encroachments by the Iranian citizens into Ecolian territory, as these were actions undertaken by civilians of their own volition. Further, Your Excellencies, the accused made orders of immediate restoration and reconstruction of the city that would allow rehabilitation of the people who had to displace themselves of the unprecedented damage. Your Excellencies, para number, just a second. Your Excellencies, para number 7 of the compromise mentions that the accused ordered his forces to rebuild and restore the city to its former glory, allowing its rightful inhabitants to once again worship their mother nature. Your Excellencies, here it can be rightfully inferred from the phrases rebuild and restore the city that the accused ordered his military to restore the city of Ecolia to former glory. Former glory could not have been restored to the city of Ecolia without its indigenous population, without the culture that is inherent in the nature of the city. Your Excellency, it should further be noted that the words used are not about replanning the city according to the accused's needs or according to plans of annexation, but to restore it and rebuild it just as it was before it was subjected to such unprecedented damage that occurred because of a two-sided armed conflict. Your Excellencies, further, the military was stationed on the site of damage as soon as possible to undertake important policies for damage control, as the accused did not intend to cause the harm to natural environment or to transfer civilian population into the city. This shows a clear lack of cognitive element to cause transfer of civilian population or to cause displacement of the indigenous one. Your Excellencies, further, as stated in Article 30 of the ICC statute, unless otherwise provided, a person shall be criminally responsible and liable for punishment for a crime within the jurisdiction of the court only if the material elements are committed with intent and knowledge. Your Excellencies, the cumulative reference to intent and knowledge requires the existence of a volitional element on the part of this suspect. The attack in the pertinent case was committed in retaliation to the killing of 40 Rankin citizens as a result of a brawl between civilians. The defendant did not possess either the intent or the knowledge necessary for constituting mens rea as understood under the context of Article 30. The accused thus did not intend to engage in conduct that could have led to the transfer of civilian population, nor did he have knowledge of sudden exodus of Rankin citizens into Ecolian territory. Moreover, Your Excellency, the use of military force by the accused in the face of the death of 40 Rankin civilians was imperative in the moment to secure national security and sovereignty and to protect his civilians from further damage. As superior commander of the state of Arankis, the obligation General Damon holds is only to his people and their safety. Your Excellencies, it was imperative that he launch some sort of retaliation in the face of the death of 40 citizens that could not have been written off as a mere collateral damage between as a result of a civilian altercation. Your Excellencies, the count the accused is charged with is based in respect to Project Homecoming, an alleged covert operation, the detailed policy of which was reported by a newspaper of the Riverlands. Your Excellencies, publications in newspapers have a tendency to be biased or influenced for popularity. Moreover, Your Excellency, the report was retracted the very next day. A newspaper of the Riverlands, the opposing party, had no reason to censor their media unless the publication had a completely unfounded basis. Your Excellency, it is further submitted that the prosecution bases their arguments of claiming that Project Homecoming was put into action as early as 2021 off of this very single report that was retracted the very next day, and thus should not be taken as substantial evidence of crime committed by General Damon possessing intent or knowledge. Thus, the council winds up her first contention and humbly submits that General Damon should not be held liable for transferring civilian population into occupied territory. If Your Excellencies are satisfied with count 2A, the council seeks permission to move to issue 2B.
Yes, please.
Much obliged, Your Excellency. Issue 2B states whether General Damon is liable for superior criminal responsibility pursuant to Article 28, Para 1 of the Rome Statute of 1998. Your Excellencies, the Council shall again be dealing with this contention in a twofold manner. The first leg of the Council's arguments seeks to establish that General Damon did not fail to exercise proper control over his subordinates. Your Excellencies, to understand the argument better, the Council would like to guide the bench through the essential bars that are necessary to be met to hold a person liable for superior criminal responsibility. Your Excellencies, Article 28, Para 1 holds a military commander responsible for the crimes of his subordinates as a result of his failure to exercise proper control. The sub-paras of Para 1 of the article state that the commander is responsible if he either knew or should have known that the forces were committing crimes, or the commander failed to take all necessary and reasonable measures to prevent their commission. Your Excellencies, at this juncture, the Council would like to bring the bench's attention to some lines from the factual matrix. Your Excellencies, it is mentioned in para number 6 of the compromise that the retaliation launched by Rankin military employed strategic planning and advanced weaponry, both of which were precautions taken by the accused to ensure minimal damage to collaterals that were not targets of military advantage. Moreover, Your Excellencies, here the Council would like to bring the bench's attention to Para D of Article 31 of the ICC statute that states the grounds for excluding criminal responsibility. Para D states that if the conduct which is alleged to constitute a crime has been caused by duress resulting from a threat of imminent death or of continuing or imminent serious bodily harm against the person or another person, and the person acts necessarily and reasonably to avoid this threat, provided that the person does not intend to cause a greater harm than the one sought to be avoided. Such a threat, as the article states, may be constituted by another person or by circumstances beyond the person's control. I unquote. In the pertinent case, Your Excellencies, the conflict between two civilian groups in late 2022 at the Temple of Harrenhal resulted in the death of 40 Rankin citizens. The circumstances of this skirmish were beyond the accused's control. As the leader of the state, General Damon had reasonable circumstances to feel the threat of imminent danger to the Rankins living on areas bordering Ecolia. The actions of the accused to constitute a retaliation in answer to the death of 40 citizens was undertaken on necessary and reasonable military objectives, Your Excellencies. The defendant further took reasonable measures and precautions to avoid harm to the environment and ecology of the Ecolian city by using advanced weaponry and machinery to fulfill his military objectives in the retaliation. The use of precise weapons and his order to rebuild and restore the city to its former glory exhibit his bona fide intentions to not harm the environment or to transfer civilian population into the Ecolian territory. Therefore, Your Excellencies, the Council humbly submits before the bench that General Damon should not be held liable for superior criminal responsibility pursuant to Article 28, Para 1 of the Rome Statute of 1998. If Your Excellencies are satisfied with the Council's arguments, the Council seeks permission to proceed to the prayer.
Yes, please proceed.
Much obliged. Wherefore, in light of the facts of the case, issues raised, arguments advanced, and authorities cited, the defense humbly prays before the pre-trial chamber of the International Criminal Court to kindly not confirm the charges against the accused that he intentionally launched an attack with prior knowledge that it would cause long-term, widespread, and severe damage to the pristine environment of Ecolia. He is liable for individual criminal responsibility under Article 25(3)(b) of the Rome Statute. He is liable for commission of the war crime of transferring parts of civilian population into occupied territory of Ecolia. He is liable for superior criminal responsibility under Article 28(1) of the Rome Statute, and or pass any interim relief in the light of equity, justice, and good conscience for the proper impartment of justice in the discretion of this honorable pre-trial chamber. And for this act of kindness, the counsels on behalf of the defense, as in duty bound, shall forever pray. If Your Excellencies are satisfied, the council rests our arguments.
One question is there, Ms. Counsel. The question is very simple. You said that he, being a sovereign, is only liable to watch the interest of his citizens, right? But we are living in a world where disturbance to peace anywhere is disturbance to peace everywhere. Or we cannot geographically stop crises like this ecocide or environmental issues. You must have seen in the context of pollution, in the context of wildfire, etc. So, and in the context of pandemic, it's a very interesting example which happened recently. So do you mean to say that if he is only responsible for citizens of his territory, being a sovereign, does that mean that he can act irresponsibly towards the other citizens across the boundary only because they are not his citizens?
Indeed not, Your Excellency. The counsel in the defense meant to reiterate through their arguments that while in context of a situation such as this, wherein after a tranquil interference into a temple that is shared because of a shared culture between both communities, that resulted in death of 40 civilians. General's obligation in the context of security was only to his own people. But in context of an armed conflict, he also held the responsibility to respect the provisions of international humanitarian law, which he undertook by taking precautionary measures such as employing advanced weaponry and using very targeted military objectives, and also by distinguishing military combatants from civilian objects and civilian persons. As the compromise mentions, Your Excellencies, civilian persons were not harmed to such an extent that the office of the prosecutor itself, after due diligence, did not bring the charges of crimes against humanity or genocide up to the pretrial chamber, Your Excellency. That the fact itself mentions that the accused took proper care to make sure that civilians or damage to civilian objects was minimized to such an extent. Your Excellencies, in a disputed territory such as one of Ecolia, where there are such deep feelings of belongingness by both parties, the use of force in the retaliation after the death of 40 civilians was reasonable on the part of General Demon, and that is what the defense submits before you today.
Thank you.
Much obliged, Your Excellencies. It was an honor arguing before the honorable bench.
With the permission of the Excellencies, we can start with the rebuttals and sub-rebuttals.
Please proceed.
I request the petitioners to start with the rebuttal.
Your Excellency, with your permission, I submit 2 to 3 rebuttals on the case that was presented by the defense. Firstly, Your Excellency, they argue that this retaliation was proportionate and therefore they should not be liable. Your Excellency, entering other countries' territory is nowhere proportionate. And secondly, Your Excellency, we need to realize the fact that they said that there was a attempt to reconstruct the city of Ecolia. That was the statement that was made by General Demon, was we should reconstruct the city and allow its rightful inhabitants to claim this land. Your Excellency, we do not know what rightful inhabitants are by the words of General Demon. He might mean that these rightful inhabitants are his own people only. Secondly, Your Lordship, restoring another country's territory is not possible. Even if you want to restore it, under Article 8 to B4 of the Rome Statute, it is clearly stated that you should not deconstruct or appropriate any acquired territory. Secondly, Your Lordship, they say that we do not have provided any sufficient evidence to prove beyond reasonable doubt the guilt. Your Lordship, we have provided sufficient evidence because, firstly, we provide you that his speech was a verbatim speech that was recorded in a newspaper. This is a recorded statement, therefore it holds the value of a direct evidence, and direct evidences have a high probative value. Secondly, we provide you with various witness accounts as mentioned in the Moot proposition that there are witnesses and NGO reports. These NGO reports are indirect evidence, though have a lower probative value. And thirdly, we also provided with you the circumstantial evidence as is present in the present case. Therefore, by combining the direct evidence, indirect evidence, and the circumstantial evidence, we have fulfilled our duty to sufficiently provide you reason that why General Demon should be charged with these very crimes. Coming to the third rebuttal, Your Excellency, they say that this attack was pinpointed with advanced military and all care was taken off. Let's look at the fact that this attack was launched with an overwhelming force of majority. Your Excellency, such an attack cannot be said to be strategic. That is, if its intention was to target the specific areas, why such an overwhelming force was used? The use of bomb certainly indicates that there must have been a destruction to the environment. Secondly, even the general demon had envied their territory for their economic advantage, and therefore on these three submissions, we respectfully submit that there was a malified intent on part of general demon, because firstly he did not stop it, the attack was not proportionate, and thirdly the attack was widespread in terms of the intensity of this attack, as Ecolia was the largest city in that particular state, and therefore this attack was widespread. And with this, we would like to rest our case, and it was a pleasure arguing before this honorable bench.
Thank you.
The respondents kindly move forward with the rebuttals.
Thank you. With the Excellency's permission, the defense would like to start with rebuttals.
Please.
Much obliged to Excellencies. To start off, the prosecution brought up the point of restoration and how General Damon did not order restoration of it. Brought up the point of restoration. The counsel would like to reiterate, as both counsels for the defense did in their arguments, that the restoration was not proposed in a manner that would that could be construed in a way that meant that General Damon meant to annex the city of Ecolia. Coming to para number 7 of the compromise, it mentions that he asked his military to restore it to its former glory and allowing its rightful inhabitants to once again worship their mother nature. It has been also mentioned in the compromise that Ecolian indigenous population lives in Ecolia presently, and by rightful inhabitants, the General Damon means to restore the city to the Ecolian indigenous population. Moreover, Your Excellencies, the culture of both Ecolia and Arankis are so deeply rooted in traditional values, and they are so committed to worshipping Mother Nature that the restoration of the city could not be complete without restoring it to its cultural landscape and how it was before the damage that occurred. Moreover, Your Excellencies, the damage that did occur to the natural environment is not refuted by the defense. What is refuted is the intention behind the damage and also the unilateral effect that the prosecution claims it was in effect of. The defense humbly submits that the damage occurred to the natural environment was unprecedented because of the following reasons. There were catalysts that perpetuated the damage that occurred to the Ecolian pristine environment. The catalysts being a fierce armed resistance from the side of the rivulets that added to the the council seeks an extension of 30 seconds if the bench allows.
Yes, please.
Much obliged, Your Excellencies. The catalysts in the pertinent case are the fierce resistance encountered by the rivulets. As it is mentioned in the compromise, the area includes vast forest landscapes, and as there were arms used in the conflict, it could have led to unprecedented forest fires that have led to unprecedented damage to the Ecolian landscape. Moreover, Your Excellencies, there is also the mention of transferring of encroachment of Irankan civilians, which is also unilaterally put under the responsibility of Irankan military to curb. If the encroachments were interfering into the lives of Ecolian people, it could have been curbed by the Rivalian military that was not stationed on the borders of Ecolia as they should have been. Thus, Your Excellencies, the counsel for the defense rests her arguments and prays that the accused should not be held liable for the charges.
Thank you.
Thank you all the participants for their speech. Now, if the judges wants to give any sort of remark or feedback for the participants, they may do it.
Thanks to all the participants. Today, we have participated with all the councils in the 4th Justice Dipak Misra International Moot Court competition. And we have heard both the parties. They argued very well. They have presented their fact with full force. And we have enjoyed the moot court competition. Hence, in any competition, one for the defeat gets the defeat. But in this competition, everybody has on. And we all wish for all the participants for the future lawyer of this country. As a also wish that all the participants may have the brilliant careers in the profession. And we all know that this profession is the best profession, and the society of this country respects this profession and wants to get something from the lawyers to the society. With these words, I am concluding my statement with the wishing good for all the participants. Thank you very much.
Good evening to all. It was a pleasure hearing all of you on a very technical subject. Like, we didn't have the privilege during our academic life or in our professional life to deal with these cases that you are dealing with. So it is always a very educating experience to be part of moot court competition, especially dealing with subjects of international law. But one point that I want to stress always, when I interact with youngsters who are students who are participating in moot, especially in international law, is that you are considering it as a theory only because you have a mindset that we are not going to practice this particular area of law. So whatever we are doing is like a research, and this is in a more ideal situation, not in a practical sense. But let me tell you, there is a huge scope of practice in international law also, because it's an area where you don't find much competition, especially from countries belonging to this geographical orientation, Asia and the southern part. So I would urge that since you have picked up an interest in this specific area, criminal law and generally international law as such, you should keep these things in your future endeavors and give a thought of understanding it in a deep sense, thorough with the procedures, and start working on it, write articles, try to get internships in international organizations. We have a very important international organization in Delhi itself, that is the Asia Africa Legal Consultancy Organization, ALCO. And other organizations are also there, starting from ISIL. And recently, we have this branch of Permanent Court of Arbitration, which is at Hague, Peace Palace. They are going to start one in India as part of the 125th anniversary celebrations. It is going to be there in front of Supreme Court in Krishna Menon Bhavan in the ISIL building. So new developments are happening in international law. So my request to you is, please keep this interest, strive on it. And let me tell you, this is the future of litigation. And even though in our municipal legislations, even in our municipal codes, international law principles are quoted, but if you consider pursuing your interest as a practicing person or a person who deals with real life cases in the subject of international law, that would be a very good thing to do. And we are looking forward for you, the young, bright minds of India, the future of India's legal system in the larger level. If you can say, the international legal system is in your hands. And I'm so happy to note your arguments and the thought process that you have presented, answer to the questions that has been put to you. Everything was perfect. Only thing is that practice, and practice. That is the only shortcut. It's the only shortcut available to come up in the profession. So all the very best to all of you. Thank you. It was a very entertaining experience. It was a very enriching experience on a Sunday afternoon. Thanks a lot. All the very best.
Thank you, sir.
Thank you, judges, for your kind words. Now, I would request the participants to kindly leave the meeting so that the judges can proceed with scoring and further discussions. Okay. So, sir, the participants have left the meeting. You can proceed with scoring the participants and any further discussion if that is required. I am here to assist you in case of any confusion or ambiguity.
Yeah, what is the courtroom number? Like
Uh,
actually filling the evaluation sheet.
The courtroom number 1.
Do you
Respected
have the
judges,
evaluation sheet?
Yes, yes, sir.
kindly note that prosecution speaker one taken 2.5 minutes more extra. From the prosecution side, speaker one.
That's fine. That delay we can control.
actually, sir, they have negative mark in
You have a
every.
negative marking. Okay.
Yes, sir. So
But
kindly note.
others have were strict to the timings. They have adhered to the timings.
Yeah, basically they have adhered to the timing, but speaker one has taken some extra time, and speaker two in rebuttals have taken some extra time. We'll put it in the chat box precisely.
Okay. So courtroom is 1, isn't it?
Yes, sir. Yes, sir.
And team codes. What was the team codes of today's teams?
Yeah, I suggest let's discuss this. Can we actually give an evaluation based on 15 to 20? Let's.
Correct. There are
only basis of 15 and 20. Like everybody, like let's keep it tagline from 15 to 20 only.
yes. 20 is the maximum mark.
Yeah, so accordingly.
Yes. So knowledge of law. No. So these marks are to be given to each participant, or how is it done?
Team code, team, I believe.
So which were the teams that, what is the team codes that was of today?
133 is the team code 1.
Okay.
JDMC 4E team code.
133. Okay. 133. Where is it? Yes. So 133 is the team code for petitioner team, isn't it? Okay.
Yes, sir. 133, and for respondent it's 107.
Okay.
So time management for the first team, what is the deductions out of 10 marks? What will deduct?
So the prosecution side, speaker one took 2 minutes 36 minutes, 2 minutes 36 seconds extra.
So
that is point number 5, isn't it? Time management.
We are deducting.
Yes.
So we can deduct 2 marks.
So you said negative markings, and is there any range of negative markings? Like for 1 minute, 1 mark or something like that? Is it part of the rules?
Yes,
No,
sir.
no, sir. No, sir. No, sir.
It's not
It
like
says
that.
if extra time taken, the total negative marks will be deducted.
Okay. So that means we can leverage it in this time management, isn't it?
Hello, Rajiv sir.
And for petitioner, there was no speaker too.
Yes, sir, there was speaker two.
There was.
Okay.
And for speaker, for the respondent, there was no time delay.
No, sir. They completed in the time frame given.